Okay, so our next speaker is an attorney here in the Akron area, which is, as you guys may or may not know, is very close to where his not even from very close. And he has actually a broad practice, but his focus that he's going to talk about today are things that are relevant to those of us that are there. Sorry about that. His practice is fairly broad, but he's going to talk today about things that are relevant to people in this room, which are things related to, for example, FSBI and various other things. I mean, personally, I have thought about litigating as a plaintiff on various things, so it's going to be interesting to hear his thoughts about where it's appropriate to be a plaintiff, where it's not, where you're likely to get. And actually, I've helped other people. Even though I'm not admitted to the bar, I'm allowed to help people with various complaints, for example. So I do fill out some of the paperwork. I know what he's going to talk about. I have a good friend who's working through one of these issues, so I'm very interested in this as well. He's going to tell us, I hope, things, and he says he's ready for you guys to ask questions as he's speaking. So if you probably already have questions that have come up in your minds over the last several years, I'm sure he'll be able to do some. So, David, they want okay.
Responsive and interactive as I want and as you want. So we can certainly engage with one another. If you have questions as I speak, if issues come up or if we bring up something relevant or important, feel free to interact with me to just kind of stop me and ask questions. If you have general concerns, I'd be happy to allow this discussion to go wherever you need it to the extent that I'm able to answer or address your questions. That being said, also, if I let you ask questions and interact, you're much less likely to fall asleep that way, too. So I think, if the blood sugar starts crashing, everybody stay involved and stay engaged. So that you know a little bit about my areas of practice, it is true that we have a broad area of practice in our firm. Our firm was actually designed originally as kind of a one-stop shop for small business clients. But over time, as we began to do both asset management and trust and estate planning for our clients, we found that many of them encountered some of the same issues, either as small business owners or in their personal lives. They had family members who were touched by illness or disability. They may have had employees that brought up those issues from the employer side, or in turn, their extended family and friends were also touched by illness and disability. And so over time, our process has kind of evolved, and we certainly now engage in representation for simple SSI and SSDI claims. What I mean by that is not to diminish any claim individually, but simply to say that claims that involve complex litigation, that can involve numerous parties, or that can involve more tenuous issues, things that are related to emotional disabilities, things that are related to more difficult to diagnose mental disabilities. In many cases, we don't necessarily handle those, and we have a system of referring out more complex cases. But I do have a good broad base of experience with basic SSI and SSDI claims. So that's part of what we're going to address today. Essentially what I'd like to do is go over some of the biggest mistakes or biggest tips that I can see that have at least streamlined the process or helped folks out over time. Some general things that I could tell you about applying for those claims. And otherwise, as things come up, or as you get bored and want to try and distract me, just let me know. I've practiced before the Court of Appeals and the Supreme Court before, so you can rapid fire questions. I'm used to that. In a room full of lawyers, that joke would have killed, but I don't think it did. Okay. Otherwise, I will start by just bringing up the general areas of concern that I've noticed, and as things come up, or as you want to ask questions, just stop and let me know. So the first thing that I would counsel anybody who wants to apply as a claimant for Social Security is that you will be denied. Your claim will not succeed initially, and you should prepare for that. Now, if you read all of the nice websites and all of the nice tutorials that they have set up for you on the Social Security website, they will let you know, of course, that every case is different and we consider each one fairly and evenly and openly. If you look at the statistics, though, it is estimated, and the Government Accounting Office releases some of these statistics, but not all of them, approximately 80% of most claims first time out are denied. If you include the statistics they don't keep, which are that first-time claims are either diminished significantly from their claim, or otherwise amended or subject to review, it is right around 90% of first asks that receive some form of no or a reduction. So what you should absolutely expect when you apply for disability is that you will be denied first time out. That should not make you feel bad. It should not cause you to reevaluate your claim. Instead, it should cause you to reevaluate your strategy. But you should know that when you apply the first time out, you are going to get denied. So let's talk about the specifics of what that claim can include, and maybe some of the things you could do to help the success or failure of that claim. Now, before I do that, since you are in the room with an attorney, let me tell you, of course, that I don't represent any of you. This doesn't create any obligation. I'm saying that on film for my malpractice insurance. But in addition to that, you need to know that each of your claims really are different. This is a highly subjective area of the law. So what I am providing should be used as general advice only. The second thing, I like to keep all of my felonies before breakfast. So when I say, don't take this information and then use it to help someone else develop a strategy for a claim, I mean that. You really can't do that. And while there are some special rules, as Dale had indicated, for assisting claimants, unless you are certified as someone who can assist claimants, or you are an attorney yourself, to take this advice and say, I heard this really attractive bald attorney say X or Y, you can't do that. It is an impermissible practice of law, or the unlicensed practice of law, and that's actually punishable. In addition to that, you can really screw up somebody's claim if you're not careful. So it's not that we hold some great magical power here as attorneys, but at least in terms of experience, I think there are some things we can help you on. But be careful about the advice we give. It's just general advice today, and we're just kind of going over the claims. So I've got that out of the way, and again, there's a record of it. That's duly noted, so we're all set. That being said, it should also be noted that your claim will take a lot of time to be processed. Again, when you look at the websites, it sounds fantastic. They'll let you know that you'll get your first response from the claims office within 20 days. They'll let you know in about 60 days, and in about 180 days, you should have your response. I have never had that experience be true ever. It is absolutely true that if you were to submit a claim, call the claims office every day, get a response from your claims officer every day, and also physically walk in and check, yes, you could get those answers on about that timeline. But you can expect that your initial claim can take up to 6 or 8 months. And until you have a final certified answer, the final answer that you are looking for, or at least an answer that the claimant can live with, you may be looking at a process that at the lowest end is about 8 to 9 months, and at the highest end can be 1 to 2 years, depending on the level, and the type of appeals that you're doing. So that's something that you should also be prepared for. So I guess the second general tip I would have for you is be ready for a long haul when you engage in the process. It is not a fast process. It is not designed to be a fast process. And it is certainly not an easy process. But it doesn't mean that you are doing something wrong. Statutorily, these things have been designed to function as a gatekeeping procedure. And this has largely been a creation of welfare reform, for good or for ill. But when those things occurred, when welfare reform policies were instated in the mid-90s, some of what they also began to attack were so-called entitlement programs. And rightly or wrongly, SSI and SSDI were lumped in to many of those reviews. And that review process, and some of the reforms, quote unquote, have significantly lengthened the process and caused at least those initial phases to turn a lot of folks away. So, regardless of what you do, regardless of how you do it, expect that it will take up a lot of time. All of that being said, I don't think that you should be afraid to ask for help. And I think that's a good way to look at it in terms of hiring both an attorney or asking somebody to help you out as a claimant. There are individuals who can represent claimants, who can assist you with filling out your paperwork, and who actually, in some cases, can do better than attorneys at initial stages because they have a lot of experience doing it. Folks who are able to process claims repeatedly or who have been involved in the claim process over and over and over again see what works and what doesn't, and they get an idea for their individual field offices and reviews what might work and what might not. So in many cases, it is good for you to have somebody helping you and working for you. In addition to that, and I'm a little partial, but I don't think it's always a bad thing to have an attorney help you out. First and foremost, we can phrase the arguments in a legal context that makes them more effective. Second of all, it's not always killer on the pocketbook either. In most cases, there are limits on what attorneys can charge. Most attorneys charge as a contingency. And in all cases, with SSDI in particular, there are upper limits on what the federal government will permit you to charge. They can only do 25% back payments up to $6,000, and after that it's capped. It doesn't seem like a low amount necessarily, but it doesn't mean that you're going to end up with a devastatingly large attorney's fee at the end, or one that you're going to have to forward in order to engage in this process. It's also important to note that as you go through appeals or various other processes, if you are dealing with an applicant who has real financial need, there are programs along the way that can help them, whether it's assistance even in getting to or from hearing, travel allowances, assistance or stipends to help them apply. There are a variety of services that if you go in and ask about, they can help you along the way. I can't give you a list of those things individually because I don't work for the government and they change all the time. But there are certain things that you can do along the way to receive help as you go and as you make those claims. So it's something to keep in mind as well. But I think asking for help, I think possibly considering an attorney if it's a good fit for you, and working through the claim carefully that way can certainly help you out. Now, not to go against what I just said here, but I think it is also worthy to note that you want to evaluate the person you are asking to help you. It is not always a good idea, even if a close relative has helped you through the rest of the process or is assisting you in your illness, that person necessarily be the default person that helps you out. Sometimes being too close can also affect your subjectivity and your objectivity. It can both kind of cloud the facts and it can sometimes cloud the evaluation of whether or not you have a good claim. And so I think you've got to be careful about that. And this is always an easier thing for the attorney to say and then be the bad guy. But sometimes, even though mom or brother or sister has helped you out through the whole process, doesn't necessarily mean that they're the good person to act as your legal representative in front of the federal government. And I think that's something to keep in mind when you pick who will be helping you out. While it might always be valuable to have that person in your corner saying yes or no, this is a good or bad idea, you might not want them being the person who's generating the ideas and telling you exactly where the case goes. Okay, that's my general touch-all on the folks that you should involve, how you make that decision, and what the decision looks like. Let's talk about the actual claims process. And so far, any questions? Am I good right now? Now, everybody still sufficiently sedated, or go ahead?
I'm probably the only one in the room. Could you give me a definition of terms for SSI and SSD?
No, absolutely can. One is, well, I'm going to look, because the one that I always say wrong is SSI, and it is Supplemental Security Income. It can alternately be defined as Supplemental Security Insurance, but they did change the name of it. The other then is obviously Social Security Disability Insurance or Disability Income. But both of those are related terms, and one is based on need, and one is based on work history and need. SSDI, you do have to have a valid work history, and that's determined on a sliding scale. And I think there's some weird office in the government where all these people sit and come up with these strange scales. And I don't know what the hell they're based on, to tell you the truth. But what happens is they determine based on your age, they impute what your work history should have been, and then they determine a valid number of working years that you've had to have contributed in order to be able to apply. And then your payment, in turn, is based partially on that, but again, partially on this other arcane scale that they make up as well. But that's what that is related to, and that's why that D component is factored in there. That disability component requires that you have a work history with it. SSI is simply supplemental, and that is entirely needs-based. There is not a precursor that you have a valid work history to apply for that. Now, they both have their slightly different application needs and means and differences, but that's essentially what the difference is. And I'm sorry, I should have started with it. But no, it's a valid question. Yeah.
I appreciate it. And no, sorry, you're the one putting out information.
No problem. But that is the difference, and it's the fundamental difference between both programs. Sir, you have a question?
What creates this huge length of time from application to possibly getting it rejected or approved? Is it backlog, or is it just...
Yeah, there is a single line in the omnibus bills that were passed initially to create these institutions in the 60s and 70s. The most dangerous thing, I guess, is the law of unintended consequences, and some federal attorney thought it would be a great idea to include the line, any person may apply. And so that's certainly what does it. The only category is that you essentially be a U.S. resident. You can verify your personage and where you live. And so because anyone can apply, it certainly makes it so that anyone can and does. In addition to that, there are a fair amount of bad claims that they have to sort through. There are a fair amount of people who are malingering. There are also claims that people file that really don't apply. And so that it is a significant backlog in the entire system that causes that problem. Now, I can't say that for sure, but that's certainly what it looks like, both from the practitioner standpoint and from what the government has released in terms of figures.
Oh, I just figured that they know that there's a statistical probability that people who have valid claims will die in that 30 months and don't have to pay them.
That is an excellent point that you bring up. It goes back to that second thing I was saying, and that's actually twofold. You don't even have to have someone pass on if that's the issue. You can have someone just lose interest if you wait long enough. It's by attrition simply, and whether it is something serious happening to them, or they simply say, look, there's no chance I'm going to get this, so fine, I get it. People get to the no mas point, and then that's what happens. It's, I think that's part of it. But I think partially it's a backlog. Some of it might unfortunately be by design.
And a lot of people think that the government knows all, and when the government refuses you, that's it, you've been refused. You have nothing different to say today than you said to them yesterday, so they give up, they don't reapply.
Right. Well, and that's and that may be part of it too, and that's where I think an attorney's advice is important.
Exactly.
No is only no when enough people have told you enough times, and even then it might be maybe.
Yes.
So there is a significant appeals process built in, but yeah, it's worthy to note on both counts that I think attrition is a major issue, and it's whether it's on purpose or whether it's a lucky or happy consequence for them, but it does happen. Okay, so the first thing I would say then, if we're kind of clear on that area at least, is the things you want to have up front every time. An easy way to fall into danger is to not have the basic stuff that you need right up front. They put a list on their front page, they put a list on the SSI and SSD pages, the government has an information page on it in several other locations, and attorneys can tell you what to have, and folks still will sometimes miss out on these initial documents. I brought the list with me that I always go over. You need the original version of documents that say the following: proof of age, proof of citizenship, proof of income, proof of resources, proof of your living arrangement, proof of medical sources, proof of medical issues, any work history if you're applying for SSD, and you must have original versions of all of those documents every time. I make it a point, and so does my office manager, to act like a crazy person when people don't bring those in. And I will intentionally ask that people bring them to meetings they don't even need them for to make sure that they have them. And I'm not kidding about that. That's one way that you can really screw up an otherwise valid claim. When you bring in that information, it's got to be original documentation, you have to have it ready, and those are the fundamentals that either an SSI or SSDI claim begin with. And whether it's coming to me or anybody else, the person who is assisting you will cherish the fact that you have brought these documents in and are starting from them.
So you just hand your passport to you and
No.
and then that goes away?
No, it doesn't. No, and that's important to recognize, because once the original documentation is handed over, we do use it and make copies. Now, the government says that they want the original. They want to verify that they had the original at one point, and then they give you all copies back. And again, I don't know why that is, other than to avoid certain claims passing through, or otherwise to avoid false claims. And so it is a good gatekeeping procedure in terms of making sure folks who are not qualified don't bring in their information. But that is part of it. And so no, you don't lose the original ultimately, but you do have to bring the original with you. And that is an easy way up front to avoid those problems. Make sure you got all that stuff collected, and make sure you get it together before you file. Once you bring it all in, either to the attorney you're working with or you prepare it yourself, there are ways to get all those things back. But you want to make sure that you have those original documents. The second thing you want to do is you want to apply as soon as you can. I think there is a mistaken belief, for whatever reason, that you have to have been ineligible for work for 12 months before you can apply. That is not true. And what the law provides is that any disability that is the basis for your claim has to have the presumption under federal law that it will last for at least 12 months. And that is what renders you eligible. But there is no requirement, and I've heard this before from a lot of claimants, that, well, you know, I quit my job a while ago because I couldn't work, and I've only been out of work 6 months, so I'll come back, you know, when it's been another 6 months, and we can talk about applying. So that generally means, so I'll be totally destitute by then. I'll have been out of work. I won't have applied for benefits. I'll have no way to do this, and I might be homeless, but I'll see you then. Not only does it complicate the male picture just a little bit, but it is not necessary. And I think it's a real misconception about what it requires. So again, the presumption in the law is that you have a disability that would ultimately affect you for that period of time, not that it has to have affected you for that period of time. And that's something that you can get an answer about with a doctor, and something that you can help, a medical professional can help you make that determination. But for whatever reason, that's out there a lot, and there is no requirement that you be out of work for 12 months, or that you have waited 12 months before you make your first application.
I have a quick question.
Yeah.
Too. Oftentimes we get into these arguments with various agencies about whether you can work at all, or whether you can work at your previous occupational level. And I think all of us probably could work some, but we can't. Most of us cannot do what we did before.
Sure.
So this is there's a sliding scale. And I think people get very confused about that issue.
They do, and I'm going to get there.
Okay.
Or we can get there now. That would be okay. But it's there are some definite important points there about what you can and cannot do. And yeah, well, no, I think I'd be happy to jump to that, and I think that's worth bringing up unless anybody had any other issues right now. It's the standard of substantial gainful employment activity, or substantial gainful activity. And what the heck does that mean? Well, what it means is it an absolute requirement to apply for either of these programs that you not work? No, it is not. If you work substantially, will it affect your ability to get an award? Almost definitely yes, but not necessarily. And so we've entered into an area of maybe, and oftentimes what folks who help claimants with want are simple answers or fair answers. Can I get an idea of what we're looking at? Is there some metric that is evolved? Is there something I can use to evaluate my claim? And again, the answer for most agencies is, well, maybe. And it's probably a no if you want to ask, but we'll talk about it. So the standard that evaluators use is something called standard gainful activity. And what that means is if you have or are engaged in substantial gainful employment activity during the period of your application, you can be denied for that reason. Anybody have any idea what that means?
No.
Probably not. And if you do have an idea, I don't necessarily have an idea, but I could ballpark it. No, if you've got a clear answer to that, you're probably a better applicant for the vacancy on the Supreme Court than I am. What they have designed this to do, though, again, is obfuscate the truth just a little bit. But it also gives them the ability to engage in a subjective evaluation of every claim as it emerges. And every evaluator at every level is allowed to make a reevaluation of what that means. See, the scary thing about the way that the appeal process works in this circumstance is that it's not an appeal before different courts at different levels. If it were just courts, they couldn't reevaluate the facts every time. This is a creature of administrative law, meaning that they can reevaluate every part of this thing every time it goes up to the next level. And so that standard of gainful activity can be reevaluated every time. There are numbers, traditionally, that they work from. And I think the 2016 number, January 2016 number for SSD was right around, I made myself a note here, it was right around, $1,130.20. Somebody write that 20 cents mark as well. But that is the standard of gainful activity. If you make over that, there is a presumption that you are engaged in gainful activities. And if you make under that, there is a presumption that you are not engaged in gainful activity. Now, what does that mean? That still is not a determinant. It's not a break point. And nothing here is a hard and fast rule. But what that means is you start from the purpose of determination from a rebuttable presumption. You either presume that it's right or presume that it's wrong and work backwards. And that's where this thing really gets off the rails. But that's essentially the number that they're beginning with. That is the standard at which you shouldn't work over. I can tell you for sure, if you are making over that amount, you are probably going to have to quit or significantly curtail your hours in any work environment. Well, before you apply.
$1,100 per week per month.
Oh, no, I'm sorry, that's a month. Yeah, that's per month. You're going to have to make that determination and that change probably before application, because I think if it is found during the period of application, which is what they're considering anytime you apply, if you're making over that amount, you're probably out of the running. If you make under that amount, though, you can still be out of the running. And that gets to the question that you asked, which is even without the presumption of gainful activity, any employment of certain kinds could still be considered gainful activity. And that's where it really does become a highly subjective determination. But there are some basic general points. So is it entirely true that you have to quit working? No. Is there a magic number that if you earn under that amount, you're okay, and if you earn over it, you're not? No. But is it probably a good idea to reduce the amount of hours you work if you're over it? Sure. But can they still look back if there's a problem? Absolutely. And so that's kind of that's that amorphous standard that's out there. Yeah.
For people who may have had more of a professional background,
Sure.
much higher income, it seems almost a joke.
You bet. You bet. And it is absolutely unfairly skewed toward lower income folks. That's entirely true, and that is not taken into account or accommodation. And I agree with you entirely. And frankly, whether it's fair or not, I'm not trying to make a rich versus poor, educated versus uneducated determination, but the bottom line is a forensic accountant will make more in an hour than an auto mechanic. And it's just the way it is. But no, there is no accommodation given for that whatsoever. And I think if you could I think you could honestly make the argument that, say, for instance, you were a forensic accountant and you could do a couple of hours of consulting work a week. But other than that, you lack the capacity or the ability to be able to do it any longer than that, and significant accommodations were required for you to do it. Sure, I think you could make that argument. I wouldn't advise that you do it, but you could certainly try and apply on that basis and make that argument, but I think it would be a hard one to do. That's part of the reason that the subjective standard is there. You can make the argument if I make about this or even over it, but I really only have to do a little bit of work to get there. Then maybe I should still be allowed to have my claim proceed. I would not want to be in the circumstance of having to represent that client, though, because while they say it's not a hard and fast standard, it pretty much ends up being. And no, it is not fair, and it does not correctly, I think, or accurately represent those kinds of individuals who had a much higher wage. And it certainly skews in favor of folks who had a lower.
How does a timely bank employee provide short-term long-term disability?
Well, it may or may not affect that. And I think it also, and that's an important question too in terms of unemployment. It may have no bearing at all on your employer having some kind of a disability policy or you making an application for short or long term. Sometimes those can dovetail right into one another. And if you're making similar claims to every agency, you're probably okay. In essence, if your claim for a short-term disability is, I can't work, I am disabled, I'm unable to work, there's probably no issue there, because one will terminate while you're in the application process, the other application process will pick up, and you're probably okay. You're not really making any contrary claims, other than a claim at a state level, or even a claim at a federal level that would require you to say, and at some point, I will be able to work again. And that's where you run into trouble. If you're in a state where, as part of your short-term disability claim, you have to say, I will be restored to full working capacity, then you probably don't want to apply for that. An application for that actually might eliminate your SSI application. In the alternative, if you happen to be applying for other applicable programs that say, my short-term disability means that eventually I'll be able to work again, well, that's grounds for the administrator or the evaluator to turn right around and say, well, hey, wait a second, why did you fill out this paperwork that said you'd be okay?
Can I just get clarity?
Yeah, sure.
I fell into that
Sure.
category where I've been taking short term.
Yeah.
And, it's expired and
Sure.
So what you're saying is if you thought that your recovery path was going to put you in a place where you could work full time again, and so you said that you were going to do that, and in fact that your recovery path doesn't turn out that way, you actually are at a disadvantage to.
Maybe.
Okay.
And that's where, again, I don't mean to mislead, and I'm really not trying to be coy when I answer this question. And I'm really not saying this to be flippant or funny either. The answer really is maybe. And an evaluator at different stages, depending on how you couch both of those claims, and depending on how you present the claim, could make the argument that essentially you said you'd get better, what happened? Or you said you would be restored at some point, Why is your inquiry different now? Or why should we, I mean, it's essentially the classic lawyer's question, when did you stop beating your wife? Or when were you lying? Or, it presumes the answer, and it's not fair. And in many cases, it's highly prejudicial against the person who's being asked. But it is couched in such a way that, it certainly presents some difficulties for you. So there's not to say that you can't overcome it, though.
But just, yeah, that it's got it.
Now, from an employer's perspective, they will always tell you to apply for short-term before you apply for long-term.
You bet.
It's not a process where you can go straight to long-term.
Well, I guess that the information that I would give you there is, that's why you always have to ask twice, I suppose. An employer is required to give you certain advice. In addition to that, an employer will always give you advice, and I say this representing employers, that is most advantageous for the employer. Certainly I would not advise my clients who are businesses to give away the farm, and certainly would not indicate that they should help folks out with a claim that they're not empowered to otherwise help them out with. Not because they want to be mean to their employees, but because in most cases you don't know. Say if they ask you, just say these are the agencies you can contact. I would go through this process first. The signs on the wall, cheers. And that really is why in most cases you got to contact an attorney independently, or you have to talk with someone who can represent you independently. Because you're right, they'll tell you the opposite first. And they'll oftentimes lead you down a different path, or even state agencies who only have an interest in handling their individual program. They don't really care about your claim long term, and they don't really care where you end up. And I think another great example of that, and another point I certainly wanted to bring up, is unemployment. While short-term and long-term disability can have one effect, I know an effect that is always dangerous, and that I have seen two otherwise very valid claims denied repeatedly on, is unemployment. Unemployment is in fact an entirely different claim. You are making the claim that I am entirely able to work. For whatever reason, X, Y, or Z, I quit working, but I'd love to get back to the labor force. Until then, can you help me out? And that's exactly, I've given you the synopsis version, but that's precisely what that application consists of. You are essentially signing an affidavit, and you are swearing before either a state or federal entity, or both, depending on the type of extension and application you do, that you are ready to work. That can be highly detrimental to your claim for SSI, and in some cases can be fatal to a claim. So while short and long-term disability, there are ways to finesse it, and certainly one of the easiest ways in a case like yours is to address it with an affidavit and a medical evaluation. And I can think of a case in particular where I explained, look, my client is not an expert. In this case, he thought he was going to be able to get back to work. He made an improper evaluation. In addition to that, his condition worsened. There's nothing we can do about that. Don't hold him to that standard and let us be reevaluated. But I can tell you from beginning to end, if you start making the claim before other agencies that absolutely I'm ready to work and I'd love to get back to work, that's not going to do. And so you got to be very careful about how you apply, and I think a holistic strategy here works. And again, part of the issue is it's much easier to apply for unemployment. I mean, it's simply a process that you work with a caseworker for a few weeks and you can get it started. But that is a real pitfall and a real danger when we talk about how these programs work together. And that is one that will absolutely render your claim dead in the water, much more so than other claims for short or long-term disability, whether they are state or federal programs or both. I'm sure that brought up questions. Yes, ma'am?
My question is, my son has been sick for 3 years, and we have nothing except for this Medicaid insurance that's coming in. His neurologist said she can't say when he will be able to go back to work, if and how. If it's an open-ended, is that detrimental to your case, or?
Not necessarily, no. It would always be better. The way to look at it is that I always screw this acronym up too. This is an alphabet soup. Is it RCF or RFC? The referral form you have for a physician. I don't ever say the acronym because I screw it up. But it is the referral form and consideration that you can get from a physician. That is important to work with. I understand if somebody who says, I really can't say, might be unwilling to fill that out, but it may be worth approaching your doctor before an application and saying, would you consider filling this out? Or would you consider preparing part of it? And at the same time, it may also be worthwhile saying, I wish to have my son evaluated strictly for occupational purposes. Would you consider making a referral? Because there are ways to make it look like doctor shopping. which you're not permitted to do. You can't just keep asking doctors until one of them says, bingo, disabled. That can be used against you. But what you can do is say, look, I understand you don't feel comfortable doing this. Could you refer me to someone in your same area of specialty, in this case in neurology, who could do an occupational evaluation? Is that a problem? And go to another specialist who could help you make that referral or who could talk to you about that, and then support your claim with multiple referral letters, or even show that perhaps we have a report or a referral from a first doctor that is incomplete, but based on a more specialized report, we believe this is now appropriate. So no, I'm not convinced it's entirely self-defeating. It's not something you'll lose on automatically. Is it something that might get you a denial the first couple of times? Absolutely. But is it something you could also work to make clearer? I think it is. I think it's something that you could work with other physicians, you could check with other doctors, and yes, I think it's something that ultimately you could make work for you rather than against you. But it's all about how you ask the questions. And what you can't do, and what folks will sometimes fall into the trap of as well is, well, if the doctor doesn't agree with me, I'm going to ask 5 or 6 more. I'll do it all at once. We'll do it in the span of 3 months, and then I'll just go till I get one person that says yes. And that's where an administrative law judge or a supervisor is going to immediately pound you with questions about, hey, why'd you go all these places? Why don't your medical records make sense? Why doesn't this line up? Why didn't you follow up with treatment? It looks more and more like you're just looking for the answer you want. But there are certainly ways that you can address that. That's not a surefire way. Maybe the answer there is still no. I don't know about the condition, but it's something I would definitely explore. Question?
Mine was about insurance. Like, I've paid into disability insurance for years before I got sick, and they covered me for most of the time, and then just this year, they cut me off. And she said, you need to send, they've been in good contact with me, and I with them, and so then they started asking for other papers, so I did everything they asked, faxed the release forms for another hospital, and then nothing, and they said, well, we didn't.
Yeah, it's not an unusual situation. To say that there's an easy answer, there isn't. And I couch all of this by saying I don't do insurance law or litigation, and it is because while administrative law is certainly its own creature, at least it still uses some of the same rules of the road. Insurance law is a whole different animal, and in most cases there are creatures of contract. Whatever you agree to and whatever they happen to write down is what you're stuck with in most cases. And even if that doesn't work with you, and even if it's not fair, oftentimes that is what you're left with. So I would begin by saying, first and foremost, you may want to talk to somebody who is either an insurance litigator or otherwise in the insurance law field. I think that's where your inquiry should begin. That being said, if we're talking about a supplemental claim, that's not necessarily a problem. Will it present some challenges? Sure. And may it again be those grounds for the first couple of denials? Possibly. But the question simply is, that's where you get back to the part of the claim that deals with resources. The picture of my resources have changed over time. I did have accommodation and provision for myself, for a certain period of time, but if you were to say make a claim based on those facts, however, over time, those resources changed. Now you're going to have to document that, and you'll have to explain it, and part of what can be very difficult in doing that is explaining why there was a denial or why there was a problem, but it's absolutely something that you can overcome. But I think the place you got to start, though, is on the insurance side of it. You want to make sure were the claims properly denied. Was your access properly given? If not, were there any statutory laws that might apply to help get you some relief from your insurer? And if all of that is true, do you have a claim against your insurer? Because you still might. I really can't say that I would know enough, and even if I were to evaluate the claim, I might not know enough. But you have a unique situation there. The advantage, if you have one, though, is there are probably a lot of different avenues. You have a lot of different targets, too. And I think working with somebody either who did exclusively insurance law, or in some cases there are specialized litigators who do both SSI and SST in combination with insurance law. You're asking a pretty high-level question, whether you realized it or not, but it is one that you should definitely explore. And so I'm going to leave that with the Socrates answer there. I know enough to say I don't know enough. Yeah, I'm paraphrasing that one too. But generally, I think you've got a claim. Yes, sir.
Wise when you know that you know nothing.
Right, yeah. Well,
Yeah, are you familiar with having someone declared as a dependent if the parent is retired and the individual
I am.
is sick?
I am,
21?
but I think we're getting into the area of tax law at that point. And so again, I gotta defer there, because I think it's also partially a strategy issue. Did you have a question related to that though? Maybe, I am, but.
Yeah, no, I mean, is that disability SSI, but it would be under the umbrella of, as a dependent?
That I really don't know, to tell you the truth. And I don't know, I for sure don't know what the tax implications there would be. And I don't honestly know enough about that area of the law to give you a real clear picture of what that would look like. And again, I think that is some area of overlap.
It's not a tax deduction.
No, not as
monthly income.
No, yeah, I understand that, and I don't mean it as a tax question necessarily, but I think you probably want to speak to a specialist in that area too, because I think it falls outside the realm of kind of the simple yes or no claim there, unfortunately. But yes, it's something to explore certainly, especially if you have large disparities in age between the caregiver and care provider, or the person who's the in-home dependent versus the provider. Other than that, though, I am going to shy away from that one respectfully, too, because I think it is a fairly complex question, but one that's worth asking.
I am on SSDI currently, and they had me do a review here recently, and they decided that since I still have deficits, I still have issues,
Sure.
but that I have progressed enough over the years that they decided that I can work now. You know, and I haven't worked for, I don't know, a dozen years or so.
Sure.
So they said I could appeal it.
Yes.
And, or I could wait and reapply. Now, to me, that appeal is probably very likely, very low percentage in my mind of winning that appeal, just from knowing the system.
Okay.
What are your thoughts on that?
My first thought is, do you have an attorney at present?
No.
Okay, just making sure, because I can't answer that question if you do. That being said, what I'm going to give you is for educational purposes only and not necessarily advice. However, the reason that you may want to reapply is if you want to re-ask the question. In other words, that reapplication would be based on your new circumstance. The appeal would be directly related to both the determination they made about your ability to work, as well as any reduction or change in the amount of the award you presently receive. The advantage, and so I guess the answer to your question is maybe. I think if you are comfortable largely with the way that your award is now, or the adjusted award, if you can live with it, and you appeal quickly, you will be able to cement that award during the terms of your appeal. However, if you think a reapplication is more likely to get you what you want, then the reapplication or re-asking the question might make more sense. But I think it would depend very much on the evaluation of your claim at present. If you've had a lot of issues with the claim, if the claim largely doesn't meet your needs, and if it is worth going back to the drawing board, a reapplication might be in order. However, if you think you can work with what you've already got, it may make sense to continue to appeal it. And it's true, the appeals process is complex. You're going to begin by doing that review. After you do that review hearing, you're going to go before likely an administrative law hearing. At that point, if you want to keep reviewing it, they'll take you before an appeals board. And ultimately, if you keep pursuing it, you can even appeal that to a federal magistrate and ultimately a federal judge in federal court. Some of that may be worth doing, and I know it sounds like an involved process, but the reason you may want to do that is to cement the award of the progress you've already received. But I think the way you make that determination is based on, look how far I've come already. Is this something worth saving? If the claim and if the underlying amount of the award makes sense for you to keep a hand on, then I think you should absolutely vigorously pursue the appeal process and try and stick it out, because at least you'll get pauses along the way in terms of what you've already been awarded. In one sense, you have the advantage of at least having already made it through this process, a significant process, and gotten some kind of a positive feedback. That being said, if the award reduction or if the change so compromises what you already have that it doesn't make sense, maybe a new bite at the apple is what you want. But either way, I think you got to meet with a lawyer. I think you got to double check with the medical professionals who have given you the evaluations, and you'd want to couch your appeal or your new ask in terms of what all of those things are reflected in the decision. You know, if the decision agrees or disagrees with those things, that might lead you more in one direction or another. So maybe I tend to lean toward appeal, actually, because I think there are more avenues to exhaust there before you start over. And if you've come this far, I think that makes sense. But there might be a real decision one way or another that a lawyer or a professional could see that might swing you one way or another. So my gut always says appeal first and do it till it's dry, but who knows?
Okay, one follow-up.
Oh, yeah.
I'm on Medicare,
Okay.
and because of the SSDI, and if I lose the way it used to be, this is before the ACA came out,
Okay.
if we lost SSDI, then we could still buy our Medicare.
Right.
Now, I don't know if that has changed or not. Do you know?
And I do not. And part of that is the Affordable Care Act. Again, I don't mean to be political whether or not you support it. The thing from a legislative perspective is a disaster. And it is because in most cases, in order to get it passed through Congress, where they couldn't agree on a term, they would leave whole sections of it blank, and it just says, as the Secretary of Health and Human Services shall from time to time determine. That means that whenever the Department of Health and Human Services promulgates a new rule, it changes. I do not do that area of healthcare law, and I don't do it for that reason. And so again, you've kind of knowingly or unknowingly wandered into a more complex SSDI claim in this case. And yeah, I think you for that reason, I guess I would couch my last bit of advice based on what you just told me. And I think you probably do need someone to help you evaluate whether or not that appeal makes sense. If the appeal would so make it that you can't get any of what you need, then yeah, it might make sense to look at reevaluation.
What's your age, Bob? Bob, no, or
57.
All right, so would it make sense for you to send them an appeal letter and attach your resume? It's like, if you really feel that I should work, please give me a job.
Probably not. It's and in fact, I think that might just tick them off. But it's worth the
I tend to be as snarly as it is.
Yeah, yeah. It's, I don't think that'll help you.
Probably more questions.
No, well, it is a bizarre circumstance, and where essentially you're, and believe me, I understand the way frustration works, and part of this thing is managing expectations. It is not allowing this to make you too crazy, not allowing this to make you too mad, and ultimately, you cannot take these legal results personally. You are literally nothing more than a series of ones and zeros most of the time in the database. This is your life. You are living it, and you have to deal with the consequences. But you got to know they see a bazillion of these. You are a number on a docket. Questions? Yeah. Yes, sir. I'm sorry, ma'am.
It's me. Thank you. My question is when I call Social Security, now we were one of the few that walked in there. I turned my son loose on her desk, and we were granted Social Security immediately. But now they're taking it away. Because 3 years ago, we had a month where he had 3 paychecks from his 2 jobs, and he went over. So it took them 3 years to catch up and figure it out, and they want all their money back. And in the meantime, we've lost now not only we're going to lose his SSI, we're going to lose his Medicaid. So it snowballed. My question is, how do you get a straight answer from Social Security people? Ticket to work screwed us over. What I was reporting everything. I kept saying there was accommodations on his job. I kept doing everything that I was supposed to do. But yet every time I would call, well, you don't have to mail that in. You don't have to call those things in. The job is going to do it for you. We'll get it off of his yearly tax forms. And I'm sitting here going, how can I get to one person that I can get a straight answer from and not get one person saying, oh, you can't do this, and another person saying, why didn't you do this?
It does give me I'm not happy to say this at all, but the only way you can get official answers out of the Social Security Department is to sue them. And absent that, you will get a different answer every time you call. Every time you talk, and every time you ask generally. Typically the advice that I give my clients, and this is all after the fact now, I understand that, but the typical advice I give is to figure out who your case manager is once you are assigned one, and that is the only person to take answers from. Because you will get conflicting information, and it'll happen all of the time.
So who is the case manager?
I don't know in your case. But
would it be on a form, a paper? Because I never seem to get a name.
Sure.
I just get...
It is typically designated internally, but it is not something that is always provided to you. And that's actually one of the tips that I give someone is to figure out who that person is. the person who is designated to make those decisions, and that's the person you need to bother. Because if you are asking other people, and you know, I guess I don't want one of the tips to be assume that the people at Social Security are lying to you. But one of the tips I would give you is don't presume they have your best interest at heart, and don't presume that they are always giving you a complete or correct answer. And the reason for that is, you know, it's kind of the same thing here. You know, based on the first flush information you gave me on your case, I had one recommendation. Based on the developments that showed up after, the recommendation might be the opposite. And I'm still not 100%. And that same issue can be persisting for you with the status of your case. So I really don't know, but I think it's probably best to figure out who is actually making those determinative suggestions and recommendations and hold that person accountable. Other than that, unless you're engaged in litigation, that's the only way you're going to get a solid answer out of them, and it's because you have to. Sir.
So this is a two-parter. In the States, do you guys use own occupation and any occupation definitions?
Yes and no. They don't use, in terms of definition, we use a subjective determination here, and I assume are you comparing this to Canada?
Yep.
Is that, yeah, okay. Because we use a system of subjective determinations. If you wanted to go someplace in the law and look for exactly what that definition is, you won't find it. But if you want to see operative definitions that they use, they are given advisory opinions from time to time by the Social Security Administration to define those. Other than that, I might not be aware of what the Canadian law is, so I maybe don't see your. Where are you going with it?
Where I was going was, okay, if I'm a forensic, accountant, and I cannot do that job.
I just use that example because I have to pay them a lot when I use them as experts. So.
Well, there you go. So I get paid a lot of money, and then all of a sudden something goes wrong. I'm bumped down to a lower job, but I can do that fully. Where would Social Security and such, or
I gotcha. Yeah. Well, where's the? This is a scenario where you don't want to be too shy about asking. I think. I'm sorry. Yeah. Her question was, would it be best to get something like an RCF from just a primary care doctor, or is it something where you get suggestions from everybody, or would you get different kinds of letters? I would actually go the full bore on everybody. You can't be shy about asking, and I would ask as many physicians as treat and attend to you. Can you help me with this? Can you give me this information? And what kind of information would you be willing to give? The worst thing they can say is, I don't see enough to do that. I'm sorry. In a best case scenario, you will get a ton of supporting documentation that can help. And if they won't go so far as to fill out the actual form certifying your disability, they may instead provide supporting documentation in the form of a medical report or medical evaluation that can still say things that help you out. They don't have to go the full medical length of saying, it is beyond a medical certainty that clearly you are disabled to help you. They can actually just provide evaluations that might extend or support the ideas in those other reports. And I think it's something entirely useful to get. So I'd ask everybody for the maximum. And if you get things that begin to paint a picture, that's really what it comes down to. You're not asking for one single that'll do it. You're instead asking for a bunch of evidence that tends to support one general idea.
I had 3 RCF letters.
Yeah, and I think it helps.
My question is, when Dave lost his job, he got long-term disability, and it took us 2.5 years probably to get the denial letter from Social Security.
Sure.
We reapplied, and he got it. We also get long-term disability, the difference between what Social Security is giving us now, because it was a little bit more, and we'll keep continuing getting that for whatever until he's 65 or something. However, I've heard that you can work making, $900 a month or something, part-time, if you wanted to get out of the house just to do something. But I was afraid of losing long-term disability.
Yeah, it goes back to that general determination I was making there, and it does. It loops right back to that. Can he do it? Sure. Would I advise that he do it in an ideal world? Probably not.
Okay.
Can you do it to that extent or somewhere in between? Maybe. Don't look at a magic number for money. Instead, look at activity overall.
For him to get out to be able to do something.
Yeah, I think in a best case scenario, best practices is no, don't do it. I think Somewhere in between is make sure it is not gainful activity to the best of your ability, and I think you do that in part by certifying what you're thinking about doing with an attorney or a specialist before you do it, and then you can give it a shot. But yeah, you're playing with fire.
Bouncing off her question, what's the difference between long-term disability and SSI?
I don't do some of the smaller types of disability, so to give you a firm legal definition, I can't tell you. But it is. But the short answer to your question is the scope of what they cover and how they are awarded. And so some of them are state level programs, some of them are also federal programs, but it is largely a difference in scope and application. Also, it is not necessary that a determination be made about your full disability for 12 months or longer. You know, the SSI and SSDI claims all require those kind of long-term determinations about your inability and incapacity.
Maybe I'm misthinking, but isn't long-term disability connected to your employment employer?
Well, that's the difference between SSI and SSDI. One requires a work history and one is needs-based. If that's the question you're asking.
No, I was thinking, so I think what you're asking is that long-term disability, isn't it offered through your employer?
Oh, you're talking about the application and the structure of the program. It is in part, yes, but that doesn't necessarily make any difference as to the application phase or how it applies to.
So I just wanted to add to what you said about asking your doctors for disability, to complete that disability paperwork. I work in an organization I've been with for 12 years. It's the sheer volume of disability paperwork requests is huge. All the doctors are used to it and expecting it from you. So if you ask your doctor to complete the paperwork and catch your medical records and anything else you need, it's not going to be, oh my gosh, why does she want it from us? This is so common.
Like I did apply a while ago. I think I signed like a medical release for Social Security
Yeah.
access for whatever.
Yeah.
So what is on top of that?
I do them on top of it. Because there's a difference between proactively providing the information versus permitting them to peruse the records. One is a pointed answer to a question. Here I have this, make a determination. The other is, if you'd like to look, you can look at this or that. There is a much stronger claim made by one than the other, and that's where I do think it would behoove you to go ahead and add all of that. And yeah, it's not something they're going to be upset with. I'd give them a heads up as a courtesy. Certainly let the professional involved know, and you want to be as courteous in general with everybody along the way too, because it's going to make the process smoother. You may catch more flies with honey, I guess. But I think it certainly makes sense for you to add as much context and as much to your reports as you can. We've done a very dangerous thing here, by the way, which is to lock a lawyer in a room without any idea what time it is, and I've held only one individual hostage. I don't know if you want me to keep speaking or not, or what time it is, but I was just double checking.
As long as you're not billing.
All right, no, I'm not. You're okay. Yeah, sure, go ahead.
You mentioned you'll get denied the first time and you have to keep going at it, but what changes between each step? Are you running up the ladder higher, or do you provide more information?
Maybe and maybe is the question. It's more of a lateral approach until you move out. To think of this from a chart, I guess. It's not the same as going from common pleas court, appeals court, Supreme Court. That is not what happens. And until it is referred out of the Social Security process, you never are before a court. You're before an administrative law panel. Now that being said, you are going to individuals with more authority. It's first the claims manager, then it is a claims reviewer, then after that it is the administrative law judge, after that it is a panel of administrative law judges or a panel of appointed reviewers. You do all four of those things. You can supplement with additional information, but sometimes you're just asking the same thing a different way, or you're providing more context. You may get some feedback, you may not, and in most cases you will not. So are you going up a chain? Not necessarily. I mean, for instance, the difference between one administrative law judges and a panel of two or three of them is oftentimes not much. But is there a difference between a reviewer and an ALR judge? Certainly. But it's all kind of lateral movement. It's all a process through the same kind of winding questions and answers and the same individuals. The only thing that is really a significant move up the ladder is if you ultimately get a no from a panel of administrative law judges, and you certify your motion to federal court, at that point you're in the jurisdiction of whatever federal court you've entered. That is a significant move up the chain. And that is almost where some lawyers would prefer to be, especially in a very complex case, because at that point you're given certain protections that you didn't have otherwise. You're given the rights of full due process, you're given the rights of judicial review, and you're starting to create a judicial record. But beyond that, I really, again, I'm not trying to be flippant when I say maybe and then probably not is the answer to most of your questions, because it's all kind of this back and forth amorphous kind of process that really winds through many of the same hands and many of the same people along the way.
So do you think it is true, I think, that once you go from the administrative to the courts, you can then supplement the record?
You can, absolutely you can.
So that's another reason.
Yeah. Well, and that was generally what he said, is it true that you can supplement the record at that point? And that's more what I meant by the implication of the protections of due process and the rules of evidence. All of that applies at that point, and you can start building a different record. You're not simply re-asking questions or asking questions in new ways. Both parties, both you and the Social Security Administration, are now bound by the federal rules of evidence and the rules of civil procedure. And it permits you to have a variety of different tactics at your disposal. Yeah.
So I think for people that get trapped in this administrative morass, then it becomes, it's more expensive for you.
You got it.
It becomes a more attractive if you feel like you're just circling around.
Well, and it's a place to carry out final litigation for a case where a real wrong has been done to you. You know, the idea is if they are really ignoring something significant, or if they have really trapped you on the kind of hamster wheel here, just from a procedural standpoint, it's absolutely true it's more expensive. You're not bound by many of those fee coverage issues at that point. And I got to be honest, any federal court case is expensive. It is a significant investment of time. We don't just make up these fees most of the time, by the way. It is a significantly more involved case. But if you are otherwise absolutely trapped, or you feel you have a valid claim that is absolutely getting denied again and again, there are times where it really is the only relief, and where, absent the threat of, I will take you in front of a judge and I will make you explain why this is not working, answer my question, sometimes that's the only way to handle it.
This is more of a comment than I can't think of a question.
Sure, fire away.
I'm just sitting here and I'm absolutely flabbergasted by some of the things that you're sharing in terms of the, I guess, what you said, where there were sort of more, that it was more preferential to a certain income class than another. Because I think, when you're in, again, in my case, I'm on the cusp of, I can't, I'm not working full time.
Sure.
I'd like to be, and it's very scary to be early in my career and to think, wow, my income potentially no longer exists. It's this, and as long as my employer, gives me sufficient accommodation, because it's so strange to hear what you're saying about that income level where you think you should work at. That it's just like I sit there and go, wow.
Now I guess you're getting into a philosophical question here,
but
but you bring up an absolutely valid point, and it's the double-edged sword of administrative law. An administrative legal remedy can be catered to do whatever you want. It can allow the government to step in and give any power to an agency. That agency has legislative, executive, and judicial authority. And from beginning to end, it's a one-stop shop for you. But it also means that if it has the power to give you whatever it wants, it has the power to take away whatever it deems appropriate. And in not having that kind of judicial oversight, and frankly, this goes all the way back to the 60s and 70s. Congress completely abdicated their authority. They said, look, we're going to reserve the right if we want to bring you back to Congress to explain what we're doing. But other than that, we don't understand this stuff. So don't let the door hit you on the way out. And that's legislatively where we have been. There has been virtually no public accountability. And unless we are dealing with a massive travesty, they don't ever get brought before review for anyone. You rarely see turnover at the highest levels, except for the top person who changes with the parties. But otherwise, there's very little change. And other than that, you see very little review. And it is partially because many of the public officials don't want to bother with it. It's too complicated, it's too complex, it takes too much of a, if either side attempts to adjust it, the other side beats them up. If the Democrats try and adjust it, the Republicans say you're just trying to give out handouts. If the Republicans try and adjust it, the Democrats say you're trying to take away people's money. It becomes a danger with very little payoff politically. And it's a very complex issue. So you're asking a pretty deep question there, I think, if there is a question there. But no, it is unfortunate, and I think largely the difficulty it would take to tackle something like this now has made it kind of untouchable.
Well, I think that for me, it's just listening to this, and because the conundrum has been, I don't know if I would be able to work full time again, and it sounds like that I will fall through the cracks.
Yeah, yeah. I'm not happy in at least giving you that general outlay, and I hope that's not the one takeaway I'm giving you, but you might be on the line there. And I think to give you a real answer, it's, I don't know, are you eligible to run for office in your district? I don't have a good answer. And I think it is one of the inherent problems with the system we have.
I'd just like to clarify that the encephalitis that I suffered from 16 years ago was a major component of my disability claim, but the other 40% was spinal stenosis that I developed. The combination of the two was pretty much, I think, why the judge apologized.
Sure, but and what I meant by that more generally was too, you really do have to give a whole picture. It can't ever be just one thing or one piece of evidence that gives you the answer. I think I'll leave you with that then, if that helps. I've gone way over my allotted time, but it was a pleasure speaking with all of you. I want to appreciate very much, or I want to let you know I appreciate very much the opportunity to talk to all of you. I know we've talked mostly in generalizations here, but if at least this gives you a context for the process, if at the very least it lets you know that there really is a chance to do this and don't give up, and there are plenty of other ways out there to help.